Hi everyone. Today we'll be looking at the Delhi High Court decision of Cobra versus HGPNL. Now, in this decision, the court said that a tribunal has the discretion to use guesswork and rough and ready methods to estimate damages when losses are otherwise difficult to quantify. And should you like to give us a background of the judge?
Absolutely, Ritik. So back in 2011, HEPNL, the project employer in question, had invited bids for work to be started on the Haryana Power Improvement Project, which was a project aimed at improving the state's power and infrastructure systems. Cobra, the relevant contractor, won the bid for 5 different projects involved in the entire overarching project. Certain delays took place in the work to be undertaken by Cobra, some of which were solely attributable to Cobra, but the others were also attributable to other contractors involved in the project.
I understand that even though there were other delays, eventually HVPNL ended up imposing the liquidated damages solely on Cobra.
Correct. Because of this, Cobra initiated arbitration proceedings in 2016. The arbitrator ordered a refund of 50% of the liquidated damages which HEPNL had imposed on Cobra, holding that since it was very difficult to determine the apportionment of damages since other contractors were also liable for certain losses, it could employ the rough and ready method, which was previously employed by the Supreme Court in the judgment of Construction Design Services versus Delhi Development Authority, and therefore impose a refund of 50% of the total liquidated damages which HEPNL had originally imposed on Cobra.
But I understand in CDS versus the DDA case, they said that you can use these methods because there was insufficient evidence, quantification was difficult, and there was a public interest involved. Was it a similar situation in this case?
Correct. So this was also a very similar situation. There was lack of evidentiary material which could help the arbitrator in determining the exact apportionment of damages which each contractor could be liable for. This was also a project which implicated public interest since this was aimed at improving Haryana's power and infrastructure systems. Because of these reasons, the division bench of the Delhi High Court stated that the arbitrator also has a power equal to the Supreme Court when trying to determine damages when there is insufficient evidence on record to determine which contractor is liable for what damage. And therefore, the arbitrator could also undertake guesswork and undertake a rough and ready method to calculate damages.
Okay, and what did the single judge bench decide? They said this is not
correct. So when the arbitrator had originally ordered the refund of 50% of the liquidated damages, both the matter then went to appeal, and the single judge bench had reversed this finding of the arbitrator and asked the parties to seek a fresh reference to arbitration. Following which, Cobra had then appealed to the division bench of the Delhi High Court, which concerns the relevant judgment, which is the topic of discussion now. The division bench that then reversed the judgment of the single judge, holding that the arbitrator was rightfully entitled to order a refund of 50% liquidated damages in this case.
So the division bench said that CDS case is something the arbitrator could have invaded.
Correct. The division bench stated that that arbitral tribunals are also equally empowered to undertake guesswork and employ the rough and ready method, which the CDS case had also employed when determining damages.
Okay. This was very helpful. Now we actually have a good understanding of what the background of the case is. Thank you so much. And now I think we'll call upon PT to tell us what are the implications of this case and how this is likely to pan out in the future. Thank you, Vidi, for being here. As we just heard from Manch, what was the background of this Cobra versus HEPNL case? Now, what we want to hear from you is what are the implications of this case?
Sure. So I think some of these cases and the jurisprudence that we are seeing, particularly in the infrastructure and construction disputes, brings us to a very important stage in dispute resolution, particularly for this sector. I think in the past, we have always looked at construction infrastructure disputes as more like commercial disputes. And therefore, there is always a overhang or an overlap on how we adjudicate commercial disputes versus how we adjudicate construction disputes. I think the most important learning from this judgment is there is now a need where we look at the construction and infrastructure industry as a independent industry, even from a dispute resolution perspective. And why I say this is that it is not almost the same, while it looks similar, but this kind of disputes are not same as the commercial disputes. I think we need to change our practices at both the levels. First, this judgment makes it very clear that even at the time when the projects are running, what kind of documentation you need to implement. You cannot be informal about the extensions that you are seeking. You need to document if there are multiple contractors as to what kind of processes that you will follow in terms of concurrent delays, not only between employers and the contractors, but also inter-se contractors, and how it affects the overall project. And on the other hand, when a dispute arises, or let me put it this way, a claim arises, because not every claim in a construction project is a dispute. I think what requires is a proper documentation behind it. And therefore, when a claim arises for the cost associated to the delays or the extension sought, what methods that you would implement to run the concurrent delays, to look at the cost associated to those delays, who was responsible to it, whether we need experts to do the window analysis on the delays and the associated cost, and or we would continue to run our disputes on guesstimates as this judgment does. Yes, one can always find solutions in guesstimates, and that may not be entirely bad in certain situations. As we always say in generally, that not everything which is uncertain is impossible. And therefore, even if it is uncertain to look at the cost, it is not impossible to compute what the loss is. But there are enough methods, there are enough guidance available worldwide in many different forums, and many different institutions have come up with those guidelines. Now it's time for India to adopt some of those measures to avoid ultimate challenges, to avoid ultimate setting aside of the awards, and bring finality to some of these claims, rather than a debate between actual loss versus guesstimate. So that's what I feel this judgment provides us as a tool to start thinking on those lines, where we need possibly a different set of rules and a different set of jurisprudence when it comes to construction and infrastructure.
Thank you, Miri. That was very insightful. And as you very rightly said, now that arbitrators have the power to guesstimate damages in that sense, now we have to see how they actually use this flexibility. Thank you so much, and we'll see you again.